All right, so here we are on a Friday. We made it through the week, and let's uh, get straight to business about talking about an important subject that affects all of us, and yet there's so few people out there talking about it, right? So I'm so glad that UE has given us this opportunity today to talk about contracts and what are some best practices and things we might want to have them in them, and just having a greater understanding about it, because as you always hear, right, knowledge is power. So let's jump in, and first things first, I want to give a little disclaimer here. Well, first I'll give you an outline. We're going to talk about what is a contract, why you should have a contract, how you should do your contract. And we're going to especially look at some scenarios and key terms that address those scenarios that can and you might want to have in your client agreements. And then we'll follow up with some pro tips. You want to stick around for that, because that will all be going into how you could get the best bang for your buck in terms of getting a good quality agreement in place. And I want to just, I think for my benefit, UE's benefit, we're not giving legal advice here. You really, really should always work with an attorney, because what I'm covering are general principles, and there's always exceptions. You always might have special nuances, special situations, and an attorney can help you with that. Plus, every state has its own laws, its own nuances. So that's yet another reason you need to work with an attorney to really help you, given where you are. So what is a contract? I'd love it if you could drop in the chat, those of you who are here. Give me an idea. What do you have in mind when you think of a contract? What do you think it is? It's okay to be wrong. So someone says an agreement. That's good. And what else? What might be some core components? It's something that makes contracts so important. Why do we want to go out of our way to have a contract in place? I'll give you the answer. The answer is, it is a legally enforceable promise. So contracts are people exchanging promises, and they have the expectation that these promises are going to be legally enforceable. If someone doesn't deliver on their promise, the person can go to court, get an order, and compel that other person to perform, whether it's paying money or delivering a service that was required. Or if someone doesn't do what they're supposed to, maybe you can even then get out of the contract and you don't have to do the other things you're supposed to do. I mean, I have clients all the time where they enter an agreement, they do a ton of work. The other person is supposed to do other things. They're not delivering on it. They're not paying my client, making tons more work for my client because they aren't doing what they're doing, and they need a way out of it. So this ability to enforce and hold the other person to their word is very important. And that's why we have contracts. Oh, I just answered partly the next question. Why do we have contracts? Well, obviously one part is to enforce the promises people are making, but there's another good reason, and that is to set the expectations of the parties. You and that other person, in the case of your client agreement, your clients, you and your client need to see eye to eye. You want that. You want them to go into the relationship. You want them to join your program knowing what they're going to get and what they have to do. As in, like, what are they going to pay you? And you want to be clear. Can they get in? Can they get out of your contract? What are the services you're going to provide? When do they need to pay you? You want all of these things set out very clearly, so that when things go wrong or there's questions, you just pull out the contract and you know what to do. Expectations are so important. And now here's another question. Which of these two is more important? Which do you think is more important? The ability to enforce the promises or setting expectations? Give me a 1 if you think it's enforcement. Give me a 2 if you think it's the expectations. So Stephanie says 2, Christina says 2. Great. That is correct. That is the right answer. And maybe I'm going to guess what you're thinking. And the reason is because if you set the expectations right, you're not going to need to enforce your contract. And enforcing your contract is ridiculously expensive. It could take a long, long, long time. I was just hearing a case about how these two huge behemoth companies spent 10 plus years enforcing battling over the enforcement of a contract. And by the time it was finally decided, there was no point enforcing it. Everything that it was about was no longer an issue. So you want to make sure you're just both on the same page. You have a happy relationship, and that's going to save you a lot of time, a lot of money, a lot of heartache, a lot of heartache. Just the emotions when you're going through a difficulty, a challenging experience. Nobody wants to go through that. And I'm sure all of you have experienced that, right? If you've been a coach for a while, you know what I'm talking about. So setting those expectations right up front can be in a sense, a lifesaver. So here's another big question. This is one that I'm sure a lot of you maybe don't know. This is, do you need to have your contract in writing? Must it be in writing? Yes, or 1 for yes, 2 for no. You think it needs to be in writing? So see some ones. All right. So from a legal perspective, you usually do not have to have it in writing. You do not need it to be in writing, but we're going to talk about why you usually should anyway. So, and by the way, there are situations where it absolutely must be in writing or else you won't be able to enforce it. For example, if you happen to do a coaching program that for some reason is longer than 1 year, very likely your state might say you need to have that agreement in writing. But why should you have it in writing? We were just talking about this, right? You want to set expectations. And if you don't have your expectations in writing, what's going to happen? We're all humans, right? We have terrible memories. We're awful at remembering things, and we always remember things in a skewed way that usually benefits ourselves. And so you're going to get situations of it's he said or she said, and you don't want to be there. You don't want those situations, right? Where you have to say, no, that's not what I said. That's not what I meant. If you have it in writing, you skip that step. And even worse, like if it actually gets to the point of trial, you're now having to pay your attorney a ton of money to figure out what you said and what she said, and to get that into a presentable way. And then now you have to try to present that to the judge. And now you're crossing your fingers that the judge is going to believe you more so than the other person. And because you're the business, maybe they're the consumer, you're the one who's probably going to want to enforce the agreement. You're the one at a loss because the burden is going to be more on you. More is going to be expected of you. You don't want to be there. Have it in writing, have the terms clear, have the expectations mapped out, and you're going to save yourself, again, heartache, a ton of money. It's worth it to invest a little bit up front that it's there in writing, and you could avoid a lot of issues. And by the way, most contracts, I would say even your cheap templates are probably going to have a clause in there that says the agreement between the parties is just what's in that one document. And so they can't say, oh, well, there was this one email where you said this and that. A judge might hopefully say, but well, no, the contract said the contract itself is only what's in front of you. So that really could simplify things if you ever had to enforce it, but you don't want to get to that point. You want to keep people happy anyway. So you get more certainty. If you have a contract, you can feel a lot better. Really, it's gambling. If you love gambling, you like going to Vegas, you love rolling the dice, betting on the craps table, then yeah, don't have agreement. I think you'll love the rocky experience, the uncertainty. But most of us, I think we want to eliminate risks. We want to avoid the doubt, and we want to be able to have confidence that if we had to go to court, a judge will uphold what we have there in writing. And you want happy customers. You want happy customers, and you want to screen out customers, right? We always talk about making sure that your customers are qualified. Part of your qualification process can be presenting them with a contract and seeing how they react. You know, if someone really reacts negatively, they see these terms, say, well, I don't want that. Great, you just screened out someone who would have been probably a real troublemaker if you hadn't had those terms in place. So again, you do want a contract that will sift people out. You don't want too much unnecessary friction, right? But you do want the contract to help sift out people who will be problemmakers. You want to contract with the right people. That's even better at times than having the right contract. So, is there magical language? Is there any sort of required language that your contract has to have? I think this is a big question. Oh, well, first, before I jump ahead, let's look at some comments I see. So, Samantha is asking, unless it was recorded in language extremely clear and accurate, you would still lose or possible confusion. Yes, that's exactly, actually, that's a great lead into what we're going to talk about right now. So we have a contract, let's say, we have it, but what words have to be in it? That's the big question. You see a lot of legalese at times, and that might lead you to think you have to have that legalese for it to be magically agreement. You have to have this whereas clause. You have to have this hereby and therefore and these things. No, no, no. You don't need that. Even if you were with someone and you on the spur needed to come up with a contract, quickly jot down some notes and whatever, a judge would do his best to try to figure out what was the intent of the parties. So that's a nice thing to know. The judge is going to do his best to try to figure out what the parties intended. But again, you don't want to get to that point where a judge is trying to figure out what did you guys intend, because that means you're paying a lawyer a ton of money to try to explain that to the judge. And now you're going to have uncertainty because you don't know what the judge is going to say and do. So as Samantha was suggesting, you want to be extremely clear in your contract and as accurate and precise as possible to save you a lot of money and headache down the road. And I see all the time contracts which use really vague terms or they misuse terms. For example, when someone is supposed to be required to do something, the contract uses language that gives the person a choice to do that thing. And it's impossible then to force someone to do something if they have a choice to do it or not. Huge mistake. I see it in templates, so many templates, even templates I pay a lot of money for. I'm seeing that happening. And so a lot of attorneys might make the mistake. It is then a good idea to make sure you're working with a good attorney who is very mindful of these things, or that you're using contracts prepared by good attorneys, because yeah, that could be a big problem if you want to go enforce down the road. And there are so many ways where you can have vague language. And where I often see this is, I think there's this big temptation to make your contract as short and simple as possible. And in the ideal world, say, yes, that's great, right? We want simplicity, just as few words as possible. But usually that comes about because there's a compromise on clarity. Whereas something really needs to be defined out. You need to spend a little bit of time explaining how is this going to work out. Maybe the civil contract will just use one or two really vague words that can mean just about anything. And now you're back in court if you have a problem trying to explain to the judge what you think that means, while the other person is going to be saying what they think it means. And that's going to cost you a lot of money. So I really encourage you, those of you especially who've had really short contracts, think about what might be missing in there. Are there situations that could arise that aren't addressed? Are there rights that you need to be giving yourself that aren't there? Because shorter isn't always better. All right, we have a question. So what about terms of agreements on buy-in pages like UE, and then the person who says they didn't even read it? Okay, so yeah, so you have someone who didn't read an agreement, you have an agreement they didn't sign. That's great. Or they did sign, didn't read it. Great question. The law generally doesn't let people get away with that for them, because it would be disastrous, right? No one could ever rely on contracts anymore, because then someone would just always say, well, I didn't read it, I'm now exempt from it. So law by default is going to say people are presumed to have read the contracts they signed. There's a huge burden on them to overcome some reason why they didn't understand it, or there's a term hidden in there. There's certain clauses which you might need to really make bold and big and maybe repeat a few times, and that's going to reinforce the importance of those and make it even harder for a person to say, oh, I wasn't aware of this one little fine print term. So be mindful. The more important a term is and the more rare the term is in contracts, then you might want to reemphasize that. Maybe have like what I do with my template is I have an intro letter and I suggest that you highlight the really important terms there. And so if you go to prove your contract, you could also submit to the judge, oh, and by the way, I gave them this letter that mapped out these terms too. So they were aware of it when they signed. Great question. All right, let's jump in now to some examples, real world examples. Maybe this has happened to you. Maybe we've seen people posting about this on the UE page, maybe even monthly. So let's presume this coach has a 1-year program, of course, and they have a client who signs up and they're going to pay by credit every month. But 6 months in, like halfway into the program, the client quits, they want a refund, they dispute all challenges or charges, sorry. So maybe they don't even bother asking you for a refund. They go straight to the credit card. They say, cancel everything, I want my refund back. And some credit cards give clients up to 6 months to cancel charges. Ouch, right? We've been seeing this in UE's Facebook page. I've seen it multiple times a month, right? So what can you do about this? What's going to happen to this coach? What has this happened to any of you? Give me a 1 if this has happened to you. 2 know if you've been lucky and you've dodged a bullet on this problem so far. 2, good. I'm seeing 2s. Good. I'm happy to hear that. Great. Okay, good. So people here have dodged a bullet, but we know others amongst us have not. There's a good way to avoid the problem. And it begins with 1, having clear payment terms in your agreement, and then being very clear on the services that you provide, like the description of your program. So the payment terms you want to have will be, how much do they owe? How often must they pay? If it's cyclical or, periodical, you want to specify it. Every month they must pay a certain amount. And then if they're paying by credit card and it's reoccurring payment, you need to have an authorization to keep charging them. If you don't have that, you could be in trouble, and they might have a right to cancel those charges and stop the recurring payments. So you need to have all those things built into your agreement. And then you need to also have the services spelled out clear enough that then you could also show the credit card company you are delivering on the services. You could go in and say, look, I promised them access to my Kajabi suite. Look, they've had access here since this date. Boom, you prove you've been delivering services. They've been getting value. They can't say, oh, my product's never arrived yet. These are big problems. People are not getting paid because the credit card company is nervous about there not being an agreement. The credit card company is nervous about whether the services promised are actually being delivered. Remove doubt, take that away, empower yourself to defend yourself by having these payment terms and service descriptions mapped out in your client agreement. So we have another question. Does the act of clicking buy underneath a box or contract that states they agree? Okay, so is it enough for them just check a box, or do you need to click a box and say read and agreed? As a general rule, the more steps you make a person take to actually execute something, the stronger of an argument you're going to have that they actually did agree, and a court will be more likely to uphold it. So the best one is, right, that they sign their name, on a written contract or a digital contract. You go on DocuSign and they check the box there, and then they sign in with their name, all these things. That's going to be, maybe in terms of digital contracts, your best way to do it. But if you have a website, yeah, if you want people to abide by the terms on your website, then you have a little pop-up box that then they say, yes, I agree. That's going to be much more upheld than just having the terms of service at the bottom of your page and the client does no interaction with it. That's where they could really say, oh, I never saw your terms and I never agreed to them. Let's go on to example number 2. So we have the 1-year program. We have a client who exits after 1 month. But guess what? They're keeping all of your materials. They went in, they downloaded your templates, they've found a way to download your videos, your podcasts, everything. They have it all. And they have the gall to tell you they got nothing out of your program. Absolutely nothing out of your program. But you catch them. You catch them, for example, using the templates for the web page. They're giving them out as samples in their coaching program. You caught them. What happens? And by the way, has this happened to any of you? Give me a 1 if you've seen this happen to you. We see this all the time being posted in UE. The people saying this has happened to them. So I'm seeing 1. Okay, I hope that means it's a 2 for the rest of you so far. What can you do about it? I suggest having an intellectual property clause in the agreement. This is what I do in my agreement template, is I use intellectual property rights to restrict the ability of people to go use your intellectual property. Because really, your videos, your podcasts, your handouts, your materials, all these things are your intellectual property. And because it's your intellectual property, just like a house, just like any other piece of property, you have a right to include or exclude other people from using it. And what we call the right to use someone's intellectual property is a license. So it's called a license. So you're giving some people permission to use your intellectual property. And it could be temporary. It doesn't have to be once you give it to them, they always have it to them. They always have it. So I spell out in my agreement, I'm giving you a revocable license that I can take away under certain circumstances. So for example, if you somehow walk out of my program early, you're going to lose the license to use these materials. And then I would require the person to go in and delete all of these materials that they have. And then go as far to require them to sign a document saying, yes, I have gone, I deleted everything, and I'm not going to use anything. And if they actually then proceed to use those materials, you could go in and have a much easier time suing them. And to make it even easier to sue them and to scare them from using your materials, or discourage them from doing it, is you could also spell out, this is what I do, if you use my materials after you left my program early, you will have to pay me a licensing fee. And then really have it be a large amount of money to reflect the value of your library. $5,000, $10,000. If they're going to use this, then they need to pay up. And if they turn around and are sharing it with other people, then they need to pay you also for each person they share with. And then when you go to court, there's a dollar value on what the license is worth, and that might make it easier for you to prove what that person owes you. So I recommend using the intellectual property approach rather than the confidentiality approach. Some people say basically my documents, the way I do my course, everything is confidential information, and basically have the client sign a non-disclosure agreement. The risk of that is if one client turns around and maybe discloses it to the public illegally, there could be the risk that then a court or someone might say, well, now nothing's confidential, and you're having a hard time restricting the use of it. Your intellectual property rights is probably going to be your stronger, better option. And that's where I focus. So example numero tres. Let's look at a 1-year program. Someone's complaining. Nobody's ever had a client complain, right, about their program. And they want out, right? Wants out. What's going to happen? How are you going to work this out? This person's saying, I'm just not getting what I wanted delivered. I'm, really, or maybe I'm having problems with my health, or I'm having problems with my money. How is this going to be worked out with this client who wants out? I love dispute resolution clauses. And this is something that I feel most client agreements I look at are missing. When I've gone and looked at the client agreements of many people in UE, we did a client exchange or a client agreement exchange. It's really great to see what others are doing. And most of them are really, really lacking a dispute resolution. I think this is one of those where a lot of people wanted to be short with their agreements, or maybe they just bought, the standard cheap templates and missing out on a lot of opportunities to be clear in agreement what happens when something arises. So I'm just going to quickly touch on some of these clauses. We're doing pretty good on time. Maybe I can go a little bit deeper on some of these so they're on your radar. The first one is normally called force majeure. This is definitely one of these lawyer-only terms that nobody else really uses in the real world. But it basically is referring to acts of God. These are events that or circumstances beyond one's control that might make it impossible for you or your client to do what they need to do under the agreement. This should be almost standard in every single agreement, yet I'm shocked how so many client agreements don't have this in it. What happens if you are the main person in your program, you get sick, you have to go to hospital, you have to get surgery, and for 2 weeks you're out. Maybe you're supposed to be constantly putting out content. Your customers might get really angry, right? And hey, you promised we're entitled. But if you have the force majeure clause, now you can be covered, say, hey, look, this is beyond my control. You guys need to give me some time. Think of COVID, right? COVID was one of the biggest acts of God that's really hit the nation lately. And I had clients who, let's say, had an event facility. They were supposed to host events there, and then the government shuts them down. But fortunately, they had a force majeure clause that said, hey, if we're shut down, we're not going to be breaching the contract, and you need to work with me to reschedule. So think of having that in place. The big question for you is going to be, though, do you want your clients to have an excuse if they don't have enough money to pay you? It's definitely not uncommon, or I should say it is common for people in our situation as coaches to say it is not an excuse to just say you don't have enough money. Now, does that mean you now must be a mean person and not work with someone if they actually are going through hard times? Absolutely not. We're just talking about your legal rights, but we see UE demonstrate it, right? Where at times they're very graceful with people. You could be understanding with someone's situation. What are they dealing with? Come up with some sort of plan. Like you could have a process in place, a policy. You don't have to be just a mean person exerting your rights to the max. But you have it in place, though, still, so that's the baseline. That's the expectation of people going in, and then you can work with it from there. So the next one is going to be material breach. What is material? Most of you think of material as in something physical, stuff you pick up, right? To lawyers, the term material usually means something that's really important or something that's at least not trivial. You don't want someone to run to court every time there's just one little goof up under the contract. Judges will hate you. Judges will say you don't even belong in my court. There needs to be a certain threshold of what's the mistakes going on in the contract being so bad that a judge will finally say, yeah, it's worth my time. It's worth all the court hours. It's worth all everybody's attorney's hours to deal with this. That's more or less what material is getting at. Again, I've been shocked at how many people do not have in their client agreements something defining what is a material breach. Because if you don't define it, you're now at the mercy of a judge to figure out what is and isn't a material breach in your contract. So maybe someone's not doing something, and to you, that's really important, and you want to hold them accountable, but the judge might say, no, that's not material. Or vice versa. If your client is supposed to be doing something, like at how many months of them being late, how many missed payments does it take before that's material? And you want to be able to enforce your rights. So you might want to be very clear. You missed one payment so many days late. That's a material breach that I can enforce. And you don't want to just stop there. You don't want to just be clear on what's a material breach. You also, I suggest putting in a process to work out disputes. You want to maybe require one party who's not breaching to give the party who's not doing what they're supposed to do maybe like 14 days notice. And what I mean by notice is you send them a letter, you send them an email, say something like, hey, you're promised under the agreement that you're going to do something and you're not doing it. You need to do that within the next 14 days. And why that's important is, again, if you have a client who's complaining, not liking the program, saying you're not delivering on what's promised in the agreement, you can say, hey, thank you for bringing that to my attention. Let's work on that within 14 days. Or vice versa. You can give that client then 14 days to fix what they're doing. And it gives you a period of time to work things out, to, iron out the wrinkles, hopefully. That's how I approach it with my agreements. I also include in my agreements something that I'm surprised doesn't show up enough, and that's before someone can run to court and just sue, they have to go through a particular process. And that process would be, first, the parties need to negotiate. They need to try to work things out amongst themselves. And then if they can't, then they need to discuss the possibility of using mediation. What is mediation? That's where you have an independent third person who tries to go between you and your client to work out a deal. Usually that's required once you get into court, but it's maybe even better to do it before you get to court, right? Save all the money and headache and court fees. Try to work it out as soon as possible. But you can't usually force people to do mediation. Courts do it, but if you force yourself and the client to do it, neither one of you really is in the mood to settle. Don't waste your time. So give yourselves the option to discuss it. Like, you need to make the best effort to work it out, see if mediation will work. If it doesn't, then I suggest looking at requiring arbitration. And a lot of people, I think, have that in their agreement. Well, maybe I'll say half people I've seen have arbitration in their agreements. Sometimes that's a good thing. Sometimes that's a bad thing. When is arbitration good? Arbitration is really good when it's a really big contract, a lot of money is at stake. Neither party wants the dispute to, let's say, go into court. You want it to be resolved privately, which is nice about arbitration. And you also don't want to spend tons and tons of money in gathering tons of evidence from everybody and their mother, and just keeping attorneys super busy gathering evidence. Arbitration usually is going to be much limited in scope. Arbitration is going to be much more streamlined than your typical case. But where arbitration could be a real problem is if, let's say, your program is only $5,000 or maybe a couple $1,000, the arbitration itself, just to start the arbitration and just to pay the arbiter, could be more than $5,000. And we're not even talking about what your attorney is entitled to get. So you really shouldn't just drop arbitration into your agreement just because. It's one of those things, like, everybody says, well, just form an LLC. Well, an LLC isn't just for everyone. So you want to work with an attorney, figure out if arbitration is for you. And that could be a real lifesaver, or it could be a real problem. And you might want to consider, and this is what I put in my contracts, the option for someone to go into small claims court. Because small claims courts are great. In California, it's $50 just to file a lawsuit in small claims court, but it could be $500 if you filed a real big lawsuit in regular court. So right there, it's 10% of the cost in terms of court fees. And in small claims court, you and the other party represent each other. You don't need an attorney involved. So that's, again, huge savings. But if you have an arbitration clause that says no matter what you have to arbitrate, you've just killed this option to really save yourself a lot of money and take care of the need unnecessarily. So Sarah asked a really good question. Do you need an attorney to be involved in mediation? So the answer is no, it's not required, but you might not know how to mediate yourself. You might not know what your legal rights are, how to assert them, how to work out a settlement agreement and all these things. So if it's a really serious dispute and you really need to have a settlement agreement written out and all, you should have an attorney helping you in the mediation. And the mediator is not going to be able to help you. He's not going to be able to advocate for you, give you pointers on what you should be doing. He has to remain absolutely neutral. So that's why most people do have attorneys helping them with mediation. But if mediation could be just a one day thing. You're paying an attorney, then just a few thousand. I mean, maybe a couple $1,000s at most. Hopefully, you could then get everything resolved. So Stephanie asks, is there a ceiling on small claims? Great question. The answer is yes. So in California, for example, a business can only file a small claims case if the amount of money being sought doesn't exceed $5,000. Or if it's an individual suing, the individual can sue for $10,000. And the amount does change a bit from state to state. So you would have to look at what your local rules would be there to know what your threshold is. All right, let's move on to the next scenario. Let's say a coach lives in New York and the client lives in California. And the client sues in California. Uh-oh. What happens? Now, I presume nobody's been sued, right? I hope that's not the case. But the bigger you get, the longer you've been around, the more likely it is this is going to happen to you. And you never want to be sued in a state you're not located. That's not fun at all, because now you're scrambling to find attorneys somewhere you don't have any contacts, and it's going to be a lot more costly. Now you're sort of the foreigner there. Usually it's believed that you have home court advantage when you sue where you're located, or you're being sued where you're located. So you don't want this to happen to you where you're being sued in a state you're not located in. So how do you get away around it? What's going to happen here to this coach, for example? Well, it's going to depend on what's in the contract. This is another reason why you need to have a written contract that spells these things out. First, I would take care of this with 4 clauses. One's going to be a choice of law clause. This one's going to say first that New York law, if you're this New York coach, would apply. But let's say you're based in Florida, then you would say Florida law. Or if you're based in Texas, you want to choose Texas law most likely. It has to be a law that is very closely related to the state in which you're living in, operating in, something like that. And then you want to also choose a forum or venue. That's a fancy name for like a court. If what court would someone have to sue in? Or if it's arbitration, where is the arbitration going to be held? You want to control that. You want it to be your home court advantage. You want it to be the state where you're located. You want it to be where it's convenient for you. You want it where hopefully the attorney you have on retainer is located. You could use arbitration also as I mentioned, to say these disputes aren't going to be resolved in court. They need to be resolved out of court in arbitration, being held in particular state. And if so in this scenario where the New York coach is sued in California, all his attorney would have to do is file a document saying, hey, we have an arbitration agreement. This case does not belong in California state court. And boom, you can almost put an instant stop to that case in California. Judges almost always are going to respect arbitration. And even if that person might say, oh, there's no valid arbitration agreement, that judge might say, well, I'll leave it to the arbiters, the people in arbitration, to decide that. It's a very powerful device. That's why people often like arbitration. But again, it might not make sense for you. The fourth one is one that I would say is more unique to me, because I've looked and I've not seen anybody else doing this. This is more of a really pro technique for those of you who are really scaling, you're growing your business, you're doing a lot across state lines, and you need to be really mindful now of minimizing your footprint in other states. You want to keep yourself from getting sued left and right. You don't want to be subject to the laws of every state. you need to start taking steps now to minimize the states you're located in, basically. And the technique to help with that is using an order form. So this is very common in the sale of goods, physical objects. You want to go buy nails. You want to buy 100 nails. You fill out the form, give me 100 of these nails. But you can use that same concept for your services. You might want to have maybe a couple services. Maybe you offer a one-on-one service, and you offer your coaching program. And then the client could go in, check the box for which ones they want, and then they submit the order form to you. And now you at your headquarters have the right to accept or reject that order. And what is this doing is now it's creating the contract where you are located. Because by default, a lot of courts might say the contract's going to be created where the contract is accepted, and they might say it's going to be accepted where the client's located. And if it can be created where the client's located, that gives the client one more argument to be able to sue you in the state where they're located. You want to take that argument away. You want to empower yourself now with an order form that will help make sure the contract is formed where you're located. But as others have pointed out to me, the order form can also serve a very nice functional purpose too, because you can front load some of the really important terms into that order form. They're now not facing a longer agreement. They're getting the important stuff up front. They're seeing it all right there. They might not bother looking at all the other stuff, even though they should, but you got the main terms right there in front of them, and they might be more willing to just sign on the dotted line that's closer to the top in a sense of the agreement. So it could reduce friction, and you might see potentially better results there. And what's nice about order forms is people are expecting to check boxes on it. So you could put more boxes on there that, they're aware of your no refund policy. They're aware of you're not providing medical services or legal services, things like that. And I think that because they're now checking boxes, they're a lot more engaged in that process. You're going to have a stronger argument to hold up in court. So let's see, I think we got some more questions come in. Okay, so yeah, as Wendy says, it's important to, putting things up front can make it look like you're not hiding things and build trust. Yeah, that's a good point. You definitely want to, as I said, anything that is more unique that people might not see all the time, put it up front, make them check a box that they're aware that's in the contract. You're not hiding the ball. All right, so sorry, Winnie. Just came in. Okay. I have a question about podcast agreements. Is there certain things we need to have in there? Actually, some of the things we covered will probably likely need to be in a podcast agreement. Usually one of the most important parts of the podcast agreement will be the intellectual property part of it. So who will own the rights to, bingo, Samantha got it. So you want to have in there who will own the rights to that podcast. And another component of it will be the media release. And, it's funny, I've done appearances for people. Nobody yet has asked me to sign a release. It's sort of implied, I think, when someone shows up to a podcast that it's okay to use their name, to use use what they say, use the picture that's provided to them. It's implied. The guests want that exposure. But ideally, I think you want someone to sign an agreement where if you're the host, for example, you say, I own this podcast, I have exclusive rights to it, I'll let you use it. You can, post it on your webpage. Also, you can share it with people. And you're giving me permission to use your name, your image, and what you say in it. And on that note of the release, some client agreements do have releases baked into their client agreement, such as the right to use testimonials, or what it happens during like a recording like this. Like if one of you turn on your camera, you ask me a question, and then UE was to post that, you know, maybe if you really want to be careful and cover yourself, then you could also have a release in case people show up in recordings. Okay, and I see there's a question of, would the order form come before the contract is given? So, yeah, great question. The way I do it is I have the two together. So you have the order form that's at the front, and then the order form says, included with this order are the following terms of service. And then the terms of service will have more of the details there in it, but all the really, really important stuff like payment terms, what's going to be in the services included, I'm going to have that more in the order form itself, and then everything else in the terms of service that go with it. And I try to have them all attached together as one document. You really run into problems if you just reference these other documents here and there. For example, often you might see people referencing the terms of service in their web page or the terms of service here and there. That just creates lots of confusion, a lot of uncertainty. Your attorney might have to go back and recreate the past because nobody maintains really good records. The judge might be skeptical about you making people be bound to agreement that might keep changing and they have no idea what's in it. So just avoid uncertainty and just have one document that flows and has everything there. All right, so let's go on and talk about example number 5. And this one is more about how do you sign your agreements? Because I see this mistake again and again and again. So let's say the coach is an LLC and they go and sign their agreement as, you know, they'll sign under the name of the agreement, but then for the title of the coach, they'll say owner of that LLC. And then the client is a corporation and the client signs as their DBA, and maybe that DBA isn't registered. And when I mean DBA, it's a fictitious name. So maybe they're XYZ Corporation, but they're doing business as ABC Corporation. That's not their real name. That's not the real business, but they sign as their DBA, and then they have a low-level employee sign the agreement. Let's talk about this. Oh, I'm blocking a little bit. Let's talk about this. So first off, have any of you signed agreements as owner, quote unquote, owner of your business? Give me one if you've done that. Anyone signed as owner? Yep. Okay. Thank you for the honesty. Anybody else done that? I see this all the time when I go and speak into groups. I see almost everybody in the group all of a sudden go, oh, wow. Oh, no, I've been doing that. I had a client who signed a lease as an owner, and that caused a lot of problems for me because they meant to sign as their LLC and they meant to use the name of the LLC, but they didn't. They signed as owner and they signed with the LLC's DBA. But then they got sued on the lease as an individual. And it just was easier for me not to spend the hours and hours and days trying to argue that no, they really meant the LLC. So they were held personally accountable. We couldn't just have bankruptcy of the business as an option because they signed it basically as themselves. The point of having an LLC or corporation is so that you sign agreements and you're doing business as that business, separate apart from you as the owner. There's supposed to be an ownership or a separation between owners and the businesses when you have an LLC or a corporation. Don't sign as an owner. You're undercutting the whole point of having that separate business entity. So how do you sign? You want to sign as first full legal names, and then you sign with authorized officers, and you sign, like, for example, if you're an LLC, you sign as the manager of the LLC. Or if you're a corporation, you sign like as the president of the corporation. Those are the usually the authorized officers of those businesses. So by default, usually LLCs are going to have their managers be the ones who can sign. And what this also means, if you're contracting with people who are LLCs, you need to do your homework and make sure that they are also signing as managers of the LLCs. You don't want just some random employee of theirs signing, because that person might not have the authority, the power to bind that entity. And likewise, you want to make sure you get the names of the businesses right. You want to make sure that they're not signing as LLCs or as DBAs. Make sure you can look up on government websites. Like every state should have a Secretary of State who then has a search where you could go in, type in the name of the business, and then see if they're there, see if they're still valid as a business, see who are the registered officers of it. It should tell you who are, like if it's a corporation, who's the president, who's the treasurer. And you could give yourself a lot of cover right there if it becomes a really bad contract. This is most important, especially if you're doing business to business work. If you're dealing with individuals, right, then you just need them as an individual to sign the agreement. So someone asked on Facebook, what do you put when it asks for your title? So good question. Good question. So your title again would be based on what type of business entity you have. Usually, you can always give yourself whatever title you want, but I have yet to encounter someone who has properly gone through the steps to give themselves a new title different than the default ones. So you want to, if you're a corporation and you're filing documents with the government saying you're the president or CEO, sign your contracts as president or CEO. If you are an LLC, you probably, in your state, is probably going to have you be a manager, and then you would sign as a manager. You could always work with an attorney who would know the specific laws of your state. You could look at the specific situations you have to tell you for sure. Again, there's different ways to change it, but that's probably going to be the way to approach it. Yeah, so someone says that they've signed as a founder or owner in different agreements. Yeah, so even founder that's not really much different than owner, and that doesn't have really any legal significance. So if that party you were signing with was paying attention, they would say, wait, no, I need you to sign as like president or something else. So yeah, this is why I'm highlighting it, because so many people I'm finding are doing this wrong, because sadly we never educate people how to do business when people are going through school, and there's not enough really clear materials out there on the internet, I'd say, explaining these things. So I'm glad you're catching this, and I guess we have just a couple of minutes left, right, Christina? So I'll give you just a couple quick pro tips then to save you some big money as you go through with your contracts. So just first, when you think about, how much money does it mean for you to have a good client, to keep them happy over the course of your business? We talked about like thousands of dollars, $10,000, $50K. It's really worth it, right? To keep them happy, to have a good ongoing relationship. And then just think of the cost of the problems that can arise. If you're hiring attorneys, we're talking about $10,000, $50,000 for a lawsuit. You want to avoid that. And then we're talking about, right, enforcing your intellectual property rights. You got money on the table when people are taking your intellectual property and abusing it. So you could be charging them tens of thousands of dollars there too. So if you have the right legal in place, that's going to save you a ton of money. And how you can go about doing it a smart way. And there's people, legacy leaders, who do what I'm about to show you. So this isn't just, me telling you to do this. Other people are actually practicing this. Is one, you go and buy a good template. Don't just buy your cheap dollar store template or some freebie one or hodgepodge something together. Start off with a good, decent template, and then have an attorney review it. And that's going to save you a lot of money, because if you pay an attorney write it from scratch, you're going to pay like $5,000 maybe if you're getting a really good template. And the attorney might not be an expert on the templates because he didn't spend weeks drafting a really good template. So You want to buy a good template, have that attorney then review it. He can just, he can make sure it's good under your law, your specific state's law, look for any problems that maybe that template doesn't address, tailor it for your situation, make sure you filled in all the boxes correctly. And that should take that attorney maybe only 1 to 2 hours. So what this means is maybe you pay $500 for your template, $500 for your attorney to review it, and you're only out $1,000, and you have now 2 steps to giving you a really solid contract. So that's what I really recommend you approach for getting good legal in place for your client agreements. And as I mentioned, people are already doing this in UE. And it's a great idea. I think this is your best bang for the buck. So thank you so much. And I don't know if you need to go.
Really quick question. I want to honor everybody's time. It is 2 o'clock, but one question that was in the chat was, how do you handle like being on a call like this and you're showing your face and your voice, and then it's going to go in the membership site? Is there something in the contract that covers you for that?
Talk about as in what context? Like talk about for your clients?
Right. The question in the chat was, how do you formulate the posting of live calls in your library? Example, I ask a question on this call, and now you see my face and you hear my voice and my name, and then that's posted in the UE library.
So as well, I mean, if you're the coach, ideally, then the coaches should have a release in place that gives them permission. But like here we have, like on Zoom, by default now, when you start recording, it says, we are recording and people have to consent. It's all contextual. If it's a public event, it's presumed people can take pictures of you, that they can record you, that's going to happen. The more private of an event it is, then that's more likely when you need to have a release in place. And especially if someone's going to be making a lot of money off of your name, off of your appearance, then again, that's the more reason why that person should have a release in place.
Perfect.
Just really depends.
Great. This was really helpful. This was wonderful. Thank you so much for your time. We appreciate it. Thank you everyone for being here.
Thank you so much.
See you next week.